I'll move on to patents now. I'm going to talk probably more about patents than the other three. They tend to be my stock in trade. A patent is essentially a deal between a government and an inventor of some new technology. So in return for giving the inventor a trade monopoly on that thing, the other side of it is that the invention gets published. And the point of that is to let other people see what you're working on. So this encourages innovation and technical development. It means expertise gets shared and technical fields move along and upwards. You can get patent protection in most of the world, not all. There are certain states that just don't have intellectual property offices, but for general purposes you can consider all of the world for patent protection. And they're valid for up to 20 years, again, as long as you keep paying the renewal fees. One of the really important things to think about with patents, though, is they're a negative right. It doesn't give you any legal right to do something. It only gives you the legal right to stop somebody else doing that thing. And it's important to note in relation to this that there is no patent police. So if somebody else is infringing your patent, it's down to the inventor to go after them and take legal action against them. There are three main criteria really for what is patentable. The first thing is that it's got to have a technical effect, and this means that there has to be some real world effect outside of a computer or something. It has to be doing something in the real world. They used to say industrially applicable, but that's been changed to technical effect. Now, back in the days of steam engines and things, industrially applicable was more appropriate, but now it's got to have a technical effect. Novelty is absolutely key, and disclosure is related to that. So if, talking about social media, if you're a blog writer and you have already written on your blog or on a Facebook post that you have this new idea, at that point it is considered to be in the public domain and it's gone. You can't patent it anymore. So it's very important to think about what details are given away on any publications you might make. And the third one, and this is the one that tends to lead to most of the arguments we have with patent examiners, is there has to be an inventive step. And that essentially means there has to have been some kind of eureka moment. You haven't just improved slightly on technology that was already there. It can't be a stepwise thing. There has to be some flash of inspiration that means it's qualitatively different from the technology that's already out there. And it wouldn't have been obvious to do this to the putative person skilled in the art.